guys, welcome to IP Series COVID-19 edition, where we talk about everything related from the creative and innovative aspect. Like I've always said, intellectual property is everywhere. So, aspect tradition, we will be talking about how to keep a secret the IP way, lessons from Telsa against Rivian, how much is your information worth? So let's get right into it. And we're back. So today's episode is really exciting. Basically that IP comes in form of copyright, patent, trademark, trade secret, industrial design, geographical indication. But today I'll be talking about secrets, confidential information. So I don't know if you guys have watched this series, Pretty Little Liars. So the intro is always got a secret, gotta keep it, la 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 la. So yeah, and it's all about everyone keeping a secret. So you can't tell the next person, even your closest friend. So this is how trade secret operates, and this is what I feel entrepreneurs should take really seriously. So entrepreneurs, business owners can exploit this aspect of intellectual property. So I'm going to read out a comment by Wendell Homes about secret. So he said, "To keep your secret is wisdom, but to expect to keep it is folly." So I got this from an article I was reading, that was written by Anita Nader and Alexis Vongel. Apologies, guys, on the characteristics of a good non-disclosure agreement. So I think you guys should just Google that up and read more about NDAs and how it relates to trade secrets. But if you still want me to do, further explanations, I'll gladly do it for you guys. So yeah, to the brief summary of this case, Telsa recently filed a suit against his potential rival, Rivian, claiming that they had poached Telsa's employees and instructed one of his employees to steal Telsa's trade secret. Now that's bad. And also hired Telsa's former employees and alleged that some of them had taken confidential manufacturing, organizational, and recruiting information, as well as a list of Telsa's employees. The former employees were accused of taking documents from Telsa, which was in violation of their non-disclosure agreement they had signed when they were hired. So, as an employer rather, an entrepreneur, a business owner, you're hiring someone, make sure you always include a non-disclosure agreement or a non-disclosure clause in your contract, especially your employment contract, whatever agreement you're signing to. I mean, it's really important because, like they say, you can't trust human beings except yourself. Even yourself, you really can't trust yourself, because you don't know what your threshold might be at the end of the day. But let's just move on. Apparently, Rivian has plans to manufacture and sell electric trucks, vans, and SUV. And as we know, currently Telsa is leading in that particular area. Now, according to a spokesperson from Rivian, they require that their employees confirm that they haven't and will not introduce their former employees' intellectual property into their system. I mean, that's you being proactive and not reactive again, and also putting your prospective employees on their toes to let them know that you don't take. Let me not say that you don't take nonsense. But yeah, so I think that's something that if you're an entrepreneur or a business person listening to this podcast, I think that's something you should consider. And you also need to let your lawyer know about it so he can, properly guide you on the right thing to do. So yeah, next we'll be talking about what trade secret is, why a non-disclosure agreement, types of trade secret, the requirements, remedies available. So stay tuned, guys. And thank you for listening. If you're just joining us, please stay tuned. And I hope you learned something new today. What is a trade secret? Now, according to David Bainbridge and Claire Howell, in their book Intellectual Property, actually the third edition, they defined trade secret as information that would cause real harm if it were disclosed to a competitor and the owner had limited its dissemination. So basically, if that information that you're withholding is going to cause serious issues or damage to your company or your business, especially if it's being disclosed or told to a competitor or a third party, basically, um, that and also gives the person an edge, that's considered to be, a trade secret. So, how valuable is a secret when it is considered to be an IP? It is very, very valuable as it gives you an edge over another person and is not generally known to your competitor. It is one of the greatest trade secret ever is the Coca-Cola, the famous Coca-Cola recipe. So there's this story or myth that that has been going on for years on how um, Coca-Cola's competitors tried to guess the recipe to Coca-Cola, and they even went as far as suing them to court, asking them to disclose their secret, but they never did. And today, it's been said that only two persons in the world are aware of what the recipe is, and they basically don't travel on the same airline. So you can see that they've taken so much um, precaution from making sure that their secret ingredient is not disclosed to the public. Same thing with the Kentucky Fried Chicken and any other trade secret that you might be aware of. If you study those companies or brand, you notice that they make conscious effort to make sure that the secret doesn't get to the wrong hands, basically. One of the reasons why companies like Telsa, protect their trade secret is to promote a standard of communication ethics. I mean, it tells a lot about a company, especially when you make conscious effort um, when it comes to, protecting um, that that information that you consider will give you an edge over your competitor. So, what are the basic requirements of a trade secret? Now, the information must have the necessary quality of confidence about it. The information must have been impacted in circumstances imposing an obligation of confidence. There must be an unauthorized use of that information to the detriment of the party communicating it. Now, this requirement was set out in the case. Sorry, I'm going to quote a law case, Coke against A.N. Clark Engineers Limited, 1969. I'm just going to stop there. What are the elements of a trade secret? So basically, elements of a trade secret, when it comes to cause of action, like what will make you go to court, is that the claimant, that is you who owns the information, must be in possession of that information, and that it is very, very important to you and not in the public domain, that is no one is aware of it, or it is a private information. So when you notice that people are making hush hush or whispering amongst themselves, and you're struggling to really hear what they have to say, you know that they're saying something really private and confidential. That the information, that they impact that information to someone else in condition that place that person under a duty of confidence. And I repeated that before, and then the recipient of the information misuses it or threatens to misuse it, or misuse being to publish the information or make use of that particular information. So what are the types of information that you could consider, or that say that they qualify to be a trade secret? So it could be a formula, just like the Coca-Cola recipe, a pattern, that's PATTERN, a device or other compilation of information that could be used for a period of time. It could be technical information used in manufacturing process. It could be marketing export or sales strategies or methods of bookkeeping, business management routines or procedure. So let's say Dangote has expanded into done a lot of brands. So Dangote has a cement, it has sugar, salt, um, noodles, what else? Flour. I know I saw one when I went to the supermarket today. But that's by the way, anyways. You can also include software used for various business purposes, technical, scientific, financial information, e.g., for example, business plans, processes, list of key customers. So let's say you have an employee that used to work for you before, and while he or she was leaving, you notice that a certain number of your customers also went with him. Now there are two ways or two things that could have happened. The customers could have voluntarily followed him, or he might have stolen your list of customers and start calling them up and saying, oh, I no longer work for XYZ, I've started my own, I can give you at a cheaper rate, same quality, blah blah blah. I know you guys get my point. List of reliable or special suppliers, product specification, product characteristics, purchase prices of key raw materials, um, salary structure of a company, promotional or marketing materials under development, source code, object code, that is for app developers. I'm just going to stop here. I think I've done a good job so far. So I mean, from the list I've given you so far, you already have an idea of what or the type of information that could be considered to be a trade secret. So yeah, we're going to move on to matter arising, which I find really, really interesting. So stay tuned, guys. So guys, riddle me. Why do you think you need a non-disclosure agreement, or a non-compete agreement, or a non-disclosure clause, or a non-compete clause in your agreement? So there's this perception about Nigerians and not, complying with agreements, whatever agreements it may be. They will either breach certain clauses and still be claiming rights, or would just terminate without probable cause. So yeah, so what are those basic requirements for you having a non-disclosure agreement? One, the information shared must be considered to be confidential in nature, just like our topic for today, trade secret. Trade secret is all about confidential information. That the act was done in confidence. So I'm going into this agreement with you, trusting you that you're not going to breach any terms in this agreement, and we're doing this together. And then finally, that the information you share will not be misused by either of you for commercial benefits. So if you need a proper and effective non-disclosure agreement, please holler at your lawyer, your IP lawyer. I don't know how I think I'm going to keep stressing this for every episode on why you need an IP lawyer on your team. But yeah, I think that's done. You also need to define what part of the information should be considered confidential in nature and how it can be used, who owns the IP, if any. Um, so yeah, I think that covers this part of this episode. Now, to my favorite part, the matter arising. You have issues of duty of confidence between an employee and an employer. Even though this is expressed by a contract, it is also implied by law. So while I was talking about a non-disclosure agreement, I did not specify if it was going to be between an employee or an employer. But in this scenario now, the duty of confidence rests on the employee who is employer employed. Oh my god. Who is employed by the employer. Okay, let's be serious right now. Who is employed by the employer. And this also extends to former employee. So you can't say because I'm no longer employee, I'm going to tell XYZ your secret or whatever you consider to be private and confidential. Now, if you look at our case study for today, Telsa is accusing Rivian of poaching its former employees and even asking them to steal his trade secret. Um, even gave an example of what he thought was stolen. He talked about organizational recruitment information, and if you listen to when I was talking about types of trade secret, I think I listed that. I talked about the structure, salary structure of a company, promotional, marketing materials under development, etc., etc. So as an employee, you have a duty of confidence. You owe your employer a duty of confidence to not share whatever information was shared to you in the course of your employment, even when you're not employed. I think some contracts will state that for this term of duration, you cannot share some information. However, there are some, you know, things that just come that you get used to because of working in that particular company, and it becomes a habit. So I think that's like an exception to this. Another matter arising for me is unauthorized use of any information, which could lead to economic damage. So if you share an information considered to be confidential in nature, it could, so what's come towards the company could be bankrupt at the end of the day. Um, your former colleagues will lose their jobs. Um, the company or the brand isn't going to grow as it should. It's going to take a major hit. So I think your conscience needs to come in now at this point. You don't have to be selfish about whatever you're doing. So yeah, I think that's done. Another one is privacy issues, right to privacy against right to freedom of speech or expression. I mean, you need to know where to draw the lines now. So for instance, I know talking like I'm talking now, I'm sharing information with you, basically educating and creating awareness about intellectual property. However, if in the course of recording I now say something that um let's see, I now tell you something that is considered to be a secret, you may not know it's a secret, but I know it was meant to be a secret. That won't be considered. I've breached the right of privacy of whoever told me that, and I'm not going to say right to freedom of expression, like, oh, I'm saying my mind or whatever. um I mean, as humans, you need to know where to draw the line. But I think that basically covers that part as well. Um, so moving on, how do you determine obligation of confidence on an employee? Now, this must be done in circumstances importing an obligation of confidence, that is, in a fiduciary way. Um, in a fiduciary way. Another one would be that the employee should not be tempted, though. Please do not be tempted to share or disclose any confidential information. So I'm going to, just talk a bit about employees owing a fiduciary duty to their employee. So stay tuned, guys, and I'll be right back. On employees owing a fiduciary duty to their employer is also like a company director owing a duty to the company where he works, or trustees to their beneficiary. Basically, it's all about duty of confidence. So I'm trusting you to do XYZ, and I expect you to, deliver at the end of the day. So take note that this information, if disclosed, must be the right type of information. So it's not by just saying, oh, I have, or I know the confidential, or this information that I consider to be really, 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 important. It must be the right type of information at the end of the day. Then you have social relationships. So um, this kind of relationship has to be really, it must be a close one. So I have colleagues that I'm friends with, and at some point they might disclose certain things to me that, say they are planning to do something. That person has told me that in confidence and expect that I should keep their secret. So I owe them that duty of confidence to keep their information safe and not share with a third party. Then you have indirect relationships from third parties, um, whereby you, like a senior friend who say, escalate or share information from one person to another. But now this is not done by the same person. This is done by different person. So party A tells party B tells party C tells party D, and the chain keeps getting longer and longer and longer and longer. So it's more like you're just gossiping and sharing hodges. Then last but not the least, eavesdroppers and spies. I mean, people that can't mind their business. For spies, I think basically you'll be talking about um, competitors who would want to do anything within their capacity to, get an advantage in, receiving that information that you consider to be really, really dear to your company. This can also be termed to be an industrial espionage, where trade secret gets stolen um, by outsiders. For instance, external threats, corporate spying, targeting specific technologies, initiating network attacks, access to source code, product designs, etc. etc. I mean, it's a different ball game out there. So I think that's all I'm going to say about that. So, how do you determine a breach of confidence? Now, when that information is made public, so let's say we're having a dinner, or we're at a gathering, or something is happening somewhere, and let's say we go into a fight, and I should be whispering or talking in lighter tones, but I'm raising my voice and telling the whole world or people present there your secret, so it no longer becomes a secret anymore. And at the end of the day, you end up being hurt. That's like, in human relationship. But when it comes to business side, you're not going to, I mean, sometimes it could take place in form of different circumstances and situations. Now, if you were to be a patent where your secret was, um, made public, your invention will not be registered at all, and neither would you be granted a patent at the end of the day. Now, another way to determine a breach is when that information is used for one's own purpose. And remember, I earlier said that it has to be the right type of information at the end of the day. The evidence must show that the leak can be traced back to the information that was disclosed in breach of confidence. So if I'm actually going to determine So let's use the Coca-Cola case where I said that um, the competitors of Coca-Cola even went as far as suing Coca-Cola. um let's say, for example, that the secret recipe was actually being found. Now what the company will do is they will have to trace and find out how that information was disclosed, and whoever is caught will now have to face the wrath of the company, that through disciplinary action, or whatever um way they decide to resolve that issue. So what about employees that have left a company? Do they still owe their employers any fiduciary duty? I would say yes. I mean, this also depends on the kind of contract that they signed at the end of the day. um they did say that for XYZ period of time you're not allowed to disclose or talk about whatever uh, was considered confidential in the company. If yes, then please keep your mouth shut. If no, let your conscience guide you. At the end of the day, you should, you know I think you're rather old enough to determine what should be said and should not be said. Like I earlier said, you need to know where to draw the line, um, especially when it comes to privacy and um, rights to freedom of expression. So yeah, so what are the advantages of trade secret as intellectual property? I said that our topic is how to keep a secret the IP way. So yeah, when we come back, we'll be rounding up on I'm talking about the advantages of trade secrets and the available remedies. So I'll be right back. So we are wrapping up right now. What are the advantages of um, trade secret as an IP? Basically, it does not require registration costs. So unlike copyright, trademark, patent, industrial design, where you have to register your creation or your invention in a particular jurisdiction in order to enjoy legal backing or protection, you do not need to register your trade secret. Um, however, however, just take note of this: when you're drafting your non-disclosure agreement, please pay for it. It's not free. Trade secret, that confidential information does not require um does not involve any registration costs, but drafting a non-disclosure agreement that would specify what the trade secret is all about is gonna cost you. Please pay that lawyer, pay that IP lawyer his money. Another advantage is that it is not limited in time. Now, I think Coca-Cola it's more than 90 years. Uh, but it's really it's one of like the oldest kept secret in terms of intellectual property. Um, that is the recipe. Protection does not require disclosure or registration, um, and it has an immediate effect. So, yeah, I think that covers it. Now, what are the disadvantages? For every advantage, there's going to be a disadvantage. Now, disadvantage of a trade secret is that someone can discover your trade secret through reverse engineering or by sheer luck, um, whereby the person may have developed the same invention by a legitimate means. The person did not have to eavesdrop or ask a third party or send a spy or whatever. The person just stumbled on it by sheer luck. um it protects against improper acquisition, use, or disclosure. And finally, it is difficult to enforce as a level of protection, which is why it is better to opt for a multi-layered protection. So now let's use I don't know. I think I'm going to keep referring to Coca-Cola, or let's talk about Kentucky Fried Chicken and KFC. Now, KFC, the name is trademarked. The recipe is protected as a trade secret. It's also exploited its IP through franchising. Uh, what else? What else? But yeah. So if you let's talk about Coca-Cola now. The shape of the Coca-Cola bottle protected by industrial design or trade dress. The recipe, trade secret, the name, um, trademark. So that's what I mean by a multi-layered protection. So what are the available remedies for someone like Telsa that wants to or is suing Rivian? So one, um, you could get monetary compensation in the form of damages based on the actual loss caused by Riverence Act, if any. The court can order seizure based on a civil action. The court can also order for destruction of the infringing product. So in this case now, as Riverine is trying to, build an electric truck, vans and SUV, the court can order that it should be, destroyed or impounded. The court can also restrain the company, that is Riverine, from further misuse of Telsa's trade secret. So I hope with these few points of mine, you have been able to understand what trade secret basically is, how to keep a secret the IP way, how much, and also how much your information is worth from this case study. So if you learned something, please let me know. If you have questions, don't forget to send us an email to at ipseriesinfo@gmail.com, or padu PARD prime PRIME legal LEGAL @gmail.com. I'm going to take that again: ipseriesinfo@gmail.com, and padu PARD prime PRIME legal LEGAL @gmail.com. I mean, it's been an absolute pleasure talking about trade secret. I hope you guys find it this episode really useful. Until the next IP series, thank you guys for tuning in. If you just came across this podcast, thank you for listening. Please don't forget to share, like, comment, and see you next time, guys. Bye.